Bandhua Mukti Morcha vs. Union of India, AIR 1984 SC 802. This public interest litigation case was filed under Article 32 directly before the Supreme Court of India and petitioned to take steps to end child labor. The petitioner, Bandhua Mukti Morcha, is an organization dedicated to the cause of release of bonded labor, conducted a survey of some of the stone quarries in Faridabad district near the city of Delhi. On the basis of the survey, the petitioner addressed a letter to Honorable Justice Bhagwati on 25th of February 1982, alleging that a large number of bonded laborers worked in inhuman and intolerable conditions in stone quarries and mines situated in Faridabad, Haryana. It prayed for the implementation of the Mines Act 1952, Bonded Labor System Abolition Act, Minimum Wages Act, among others. The Honorable Supreme Court treated the letter as a writ petition under Article 32 of the Indian Constitution and on 26th of February 1982 appointed a commission consisting of Mr. Ashok Srivastava and Mr. Ashok Panda to inquire into the allegations made by the petitioner. The report submitted on 2nd of March 1982 by the commission stated that the whole atmosphere in the alleged stone quarries was full of dust and it was difficult for anyone to breathe. Secondly, some of the workmen were not allowed to leave the stone quarries and were providing forced labor. There was no facility of providing clear drinking water. The laborers did not have proper houses. Instead, they were living in juggis made of piled stones and straw. No compensation was paid to laborers who were injured in accidents occurring in the course of their employment. There was no facility for medical treatment or schooling. At the direction of the Apex Court, a social legal investigation was also carried out by Dr. Patwardhan. Questions of law. Whether any fundamental right of the workmen referred to in the petition is infringed so as to attract Article 32 of the Indian Constitution. Can a letter addressed by a party to this court be treated as a writ petition? Whether the Bonded Labor System Abolition Act 1976 covers forced labor. Whether or not the workmen in the present case are bonded laborers. Whether or not the workmen in the present case are entitled to benefits under various social welfare and labor legislations. Decision of the court. In its judgment, the court discussed importance of protecting children's right to education, health and development in ensuring India's progress as a democracy. While recognizing that child labor could not be abolished immediately due to economic necessity, the court found that a pragmatic or practical steps could be taken to protect and promote the rights of children in the poverty-stricken and vulnerable population of Indian society. Article 21 of the Constitution confers upon every individual the right to live with human dignity. It derives its life and breath from the directive principles of state policy and particularly clauses E and F of Article 39 and Articles 41 and 42. These rights are fundamental to human existence and make a man's life meaningful and worth living. Moreover, the court held, on account of social and economic disability of an individual or group, any member of the public can move the court under Clause 1 of Article 32 of the Constitution. Moreover, the court said public interest litigation is an opportunity for the government and its officers to make human rights meaningful to the deprived and vulnerable sections of the community and to assure them social and economic justice. This is the constitutional obligation of the government under Article 23, which prohibits forced labor in any form. The court further held that Bonded Labor System Abolition Act 1976 recognized forced labor as a form of bonded labor. Whenever a laborer is made to provide forced labor, the court would raise a presumption that he is required to do so in consideration of an advance or other economic consideration received by him, and he is therefore a bonded laborer. Moreover, the court held that the central and state governments were constitutionally obliged to ensure implementation of provisions of acts such as Minimum Wages Act 1948, Payment of Wages Act 1948, Maternity Benefit Act 1961, Bonded Labor Abolition Act 1976, etc. Most importantly, the court held that it was very important to educate the workmen of their rights and entitlements under various social welfare laws. Such knowledge would prevent them being passive recipients of exploitation and empower them to fight for securing their legitimate dues. The most important thing that the court said was that the law prescribing procedure for deprivation of personal liberty of a person will have to stand the test of both Article 19 and 21. Thank you so much for giving me your valuable time. I hope you liked the video. If you have any doubts, do comment. I'll try in the best possible way to answer the doubts, and hit the subscribe button as I'll be posting regularly such law content. Thank you.